Right, back live here on News at Prime. Thanks for staying on. An article in The Conversation has used Mkhwebane's year-long impeachment battle as an example of the politically powerful abusing the legal system. The author of that article, Narnia Bohler-Muller, refers to the strategy of vexatious litigation as a deflection tactic. She joins us now to expand a little bit more on that opinion. Narnia, good to have you, and thank you very much for coming on News at Prime this evening. Talk to us about the effects of lawfare in the context of South African politics and its effects on the judiciary. Of course, using the example that you've just picked of the impeachment of the public protector.
Thank you. Lovely to be with you this evening. I think lawfare, or what one calls delaying tactics, or the Stalingrad defense, is very dangerous for a number of reasons. And probably the most important one being that it costs the fiscus a lot of money when it comes to people like the former public protector or former President Zuma using the courts in order to appeal everything and anything. And so it's an expensive exercise, and I think that the public certainly don't want to see that. I think amounts of 160 million rand were bandied about when it came to Advocate Mkhwebane. So that's the one danger, that it's a waste of the state's money. And the other is that it affects the integrity of the courts. So people start looking at the courts and the judiciary and thinking, well, you know, are you doing your jobs well enough? Can you not be firmer with these kinds of cases so that they don't drag on, that they don't cost us that much money? It comes from the taxpayers' pockets. And we certainly don't want to see trust in the courts decline in South Africa any more than it already has. Trust in all institutions of democracy are declining, and it's a risk, therefore, to our very democracy. So I think the matter is very serious, and it's a game, a dangerous game that is played by rich people who are able to use the system to their advantage.
It's very interesting because every time myself as a journalist would bring that up with any politician, they'll say, well, we are a constitutional democracy. So it's my constitution to exhaust the processes of the courts in order to absolve myself. So the judicialization of politics is justified by saying we live in a constitutional democracy. So do we have enough enough rules within the judiciary to prevent this from happening? Some safeguards. I'm looking for that word.
Yes, of course. No, I think it's an abuse of constitutional democracy and the Bill of Rights to say that, you know, I have every right to abuse the system because, you know, of Section 34 of the Constitution that allows me to have legal representation. The Constitution wasn't written for the rich and the famous and the political. It was certainly written to protect ordinary South Africans. So the problem is that there are safeguards in place that are not being utilized, and there are some guidelines that are not in place that need to be put in place. So the safeguards would be using cost orders in courts. For example, if you have a vexatious litigant and a vexatious representative in the courtroom, and the court finds that they are using unfair delaying tactics, misleading the court, being frivolous, there can actually be punitive or personal cost orders against such individuals. We also have a number of bodies in South Africa that regulate lawyers, and this would be, for example, the Legal Practice Council, who would have to raise these issues and see that proper conduct occurs in courts and that courts are not misled. So there are elements of control that are built into the system. And another one is purely for judges to call it out. You know, you can see it when it happens. There was a Supreme Court judge in the 1960s in America who said, you know, it's difficult to describe pornography, but when you see it, you know it. And it's the same with vexatious and frivolous litigation. When you see it, you know it. And so we do need to take action against something like this because it affects the morale of citizens to see politicians abusing our democratic institutions the way that they have.
Yeah, and you say, is that a responsibility of civil society? Is that the responsibility of the judiciary, of parliament? Who should take up that responsibility of stopping this, for lack of a better word?
Well, there are a range of actions that can be taken. Of course, we would want to know that people are moral and ethical and that they wouldn't abuse the system. But of course, that's not the case. There are people who definitely abuse the system. So it would be for legal representatives to act ethically and not to use these kinds of tactics in court. They have certain training and certain responsibilities towards their clients and towards the courts. So they are responsible and should be held responsible for their conduct in courts. And that's where the Legal Practice Council comes in, for example. But judges also have a responsibility. Judges have a responsibility to ensure that they stick to the rule of law, that they hold individuals to account if they are abusing the system. And this isn't necessarily always happening. So we have seen instances of judges recusing themselves because they feel that they may be doing something wrong. And one of the reasons why I think this happens is because the judiciary has been attacked so often in the past. And so they've become judges have become more different to the executive and to other branches of government. We know that Julius Malema is constantly attacking the judiciary. Lindiwe Sisulu has done so in the past, and Chief Justices have actually had to defend themselves and the judiciary against these attacks by politicians. But it seems to be paying off because judges are afraid to make fair and just and objective decisions because of the politicization of the judiciary.
Narnia, I appreciate your time. Thanks so much for coming on this evening on News at Prime. Narnia Bohler-Muller, she is with the Human Sciences Research Council.